Director of Finance, Mr. Ortega. Chairperson Dillon, you have a quorum.
Thank you very much. So, so I'd like to go ahead and open up our meeting by saying congratulations to Ed on his retirement. This is his last board meeting with us. You can see, the audience can see from our picture taking activities that we've all dressed in honor of Ed. I'll miss you. I'm going to give it to you, Jack.
Thanks, Dana. Ed. There's so many things we can say about Ed's contributions to the organization, but I wanted to just focus on one thing, at least from my working so closely with Ed over these years and the things that he's done for CalSTRS. And, sometimes people in the private sector don't get it, how much, there's so many headwinds in getting things done, as my view, in the public sector. And people mistakenly think it's because it's government, or, it's because it's bureaucracy. And that's actually not the case. That I've done this a long time. The case is, the reason why there's so many headwinds in the public sector, it's so complex and it's so transparent, this environment. And so you're constantly working through a maze of people and obstacles and things to be successful. It's not because people don't want you to be successful. It's just because it's that much more difficult. And, in the private sector, you work in a little more of a command and control environment where you make a decision and there's things to work through. But in the public sector, there's a lot of unexpected issues. And that's what hopefully you all see that Ed has done so effectively for CalSTRS for his 18 years here, is that we picked things for him to champion that the headwinds easily would have stopped a normal person, and we would never have gotten them done at all. But Ed is the ultimate, that little phrase we love too, the go-to guy, go-to person. But he is the go-to person for those things that nobody else will get through to the finish line, to work with stakeholders, or work with the legislature, and all the things that require your antenna to be so much more developed than the average person. But he really appreciates the rich environment we work in the public sector, and is willing then to get us through. And so his list of accomplishments is that much more bold. Because in fact he's recognized that there's headwinds, but he knows how to drive that sailboat. He does, and he's got us to where the success of this organization, these will be remembered forever. So we owe you a lot.
Oh, absolutely. So we had dinner last night, and we were able to toast Ed a little bit and roast him a little bit. One of the most common themes was something that's near and dear to my heart: is Ed answers emails, texts at all hours of the day immediately. And I'm going to miss that. So that's going to be a challenge to somebody else to do that for me. We know that you're still going to be running around like a crazy man. So why don't you introduce your daughter to us and tell us what you're going to be doing next?
Yeah, so my daughter, Joanna, stand up. Stand up. This is
Joanna.
My daughter, who I talk about all the time. She's had one of the more interesting experiences in her life. She just got her graduate degree in England, and she had planned on moving to Turkey, and then there was this attempted coup, so that didn't work out. So she ended up getting a job in Florida working for the Democrats on the campaign, and so she goes there, and then there's a tropical storm. But she works like 12 to 15 hours a day, 7 days a week. She actually got the day off to come out here for this, because after 18 years, she wanted to understand what it is I actually do. And then she's
there's a lot of us that want to know that.
Early next month, after I get done here, I'm going to go there and work for her for the rest of the campaign. So I'm sure she'll take advantage of all the grief I've given her over her life, that she'll give me grief back. So, but like I said last night, the working with all of you has just been a real honor and just a real privilege, and I've really enjoyed it. And Also, if I can speak to the staff here you've got here are phenomenal. I mean, they're so talented, they're so committed to the mission of the organization, and that will lead to our success. And working so closely with the stakeholders who've been really great to work with. And I just can't say enough good things about what it's been here. And it's been a lot of fun for 18 years.
You've served us
So,
well.
and I'll definitely miss the people. I may not miss everything that goes on around here, but I'll definitely miss all of you, and I'll miss the people here. So I really
Well, then
appreciate
you're
everything.
invited to stop by anytime at all to
Well,
visit.
I'll check out the lunches and, you know.
Okay, come by for lunch anytime.
Yeah, that's right.
All right, Sharon?
So Ed, I just wanted to say in public, because I said it last night, but I do just, for all the important work that you do, I think to me, the most important work that you do is helping our members understand their retirement. So, you know, I know a lot of the stakeholders in the room have benefited from you explaining their pension to them, or the difference between DB and CB and Social Security offsets and all that fun, exciting stuff. So I just wanted to publicly thank you on behalf of all the active teachers and our retirees that, you know, at the end of the day, I know you love all the policy wonkiness of your job, but I think for me, you know, the big part of the work that we do here is making sure teachers have a secure retirement and retire with dignity and understand their retirement, and you do that really well. So I just appreciate your partnership, you know, on all our little, you know, trips around the state. And but I just wanted to thank you for the work that you've done. It's been really meaningful to our members. So thanks.
Harry?
Ed, you're a good guy.
Yeah.
Real short, that's in New York, you're a good guy. You know,
Absolutely.
That's like the highest of compliments when you come from one of the boroughs. And if you know what that means, no explanation is necessary. And if you don't know what it means, no explanation would suffice. So you're a good guy.
There you go.
And, you know, your daughter wants to know what you do. I think some people wake up every day, Ed, and they think about what they can take and what they can get. But in the time that I've known you, you wake up every day and think about who can I help and what can I give. And that's what your dad does. Your dad makes a difference in people's lives. And that's invaluable. It's invaluable. And I say that as a teacher and as a dad. That's what I want my daughters to know about their father. They made a difference. He woke up every day and said, what can he give? How can he make a difference? So thanks for the difference you've made in the lives of hundreds of thousands of California's teachers. You're a good guy, Ed.
And I'm so glad he can say that way. I'd like to open it up to anybody else in case anybody else wanted to say anything. You have an opportunity to. And seeing none, then I'd like y'all to join me with a round of applause and congratulate Ed.
Yeah, maybe I'll stay.
That'd be okay with me. All righty, thank you very much. All righty. We didn't do the agenda yet, have we? Nope, we started right off with that. Okay, so we have 3 action items right off the bat. Let's talk about approval of the board agenda and the work plan. Need a motion?
So moved. Second.
It's been moved and seconded. All in favor, say aye.
Aye.
Any nays? And any abstentions? All righty. Ed, you get to be first up. Amendments to the credible comp regs. This is the fun stuff he gets to do,
Yeah, that's right.
Joanne.
Now I have to earn my keep. That's right. So you'll remember that back a couple of years ago, the board adopted some regulations that sort of address what is creditable to CalSTRS and how it's credited to CalSTRS for compensation that's earned by the members. And back in April, we came back to the board and told the board that in the course of implementation of those regulations, there's a number of things that we've come across working with the employers and the members to try to want to clarify some items. Been some changes in state law since then. and you gave us direction to go ahead and start that process. So where we are right now is we've engaged with the variety of stakeholders to develop some amendments to the regulations to try to clarify a number of the issues. 5 in particular that we outline in TRB 4, one of which having to do with, since the regulations were adopted, the LCFF, the local control funding formula, came into place, and we wanted to clearly identify that as a state program by which, if that it could establish a class of employees if you're under a program that was created under the local control and accountability plan. We also wanted to clarify that compensation that's paid that's related to mentoring and training and assignment of teachers would be considered salary, even if it's paid as a stipend, even without regards to being the basis of future pay increase. We added some language, we're adding some language to address overloads in community colleges, as well as a comparable situation in which in the K-12, typically in the K-12 world, where compensation is paid whenever there's more than this contracted amount of students in terms of how that gets treated. And then also in addition, there was a problem that we had with, an issue that we had as a loophole with respect to a situation in which a successor person got paid less money because they got lesser experience, that there was what we perceived as what was potentially a loophole in there that we wanted to close up. So as I said, we've been working with the stakeholders to address all those issues. They've all been satisfied with the way we came up. We worked with the school administrators, we worked with the teachers, the unions, all of that, the employers. And so what we're presenting to you is some proposed language that we are recommending that you direct us to initiate the formal rulemaking process. And if you choose to do that, we would actually submit this process and go to the Office of Administrative Law, have a hearing in November at the November board meeting. The comment period would start right away, and then the November hearing would be at the end of that comment period. If there are no comments, and if during the comment period, and if there's no issues raised at the hearing itself, we would recommend in November that you actually adopt the regulations at that time so that we can implement them on a timely basis. But with that, we would be happy to answer any questions.
Are there any questions of Ed? This is an action item, so I'd entertain a motion that we adopt staff's recommendation. So it's been moved by Sharon and seconded by Grant. All in favor, say aye. Aye. All opposed, nay. Any abstentions?
I'd like to abstain.
All righty. And I'm sorry, I just didn't expect to see you there.
My computer is not working.
Oh.
We're having technical issues every once in a while. The motion passes. So Ed, if you can put that into process before you go, we'd appreciate
We'll
it.
start that. And also, just so you know, as part of the pension solution project, we're going to be modifying the information that gets reported to us by employers. And so those file specifications of those reports have to be modified, and it has to be done by regulation. So once, I'm just giving you a heads up that once we've sort of moved far enough along in that process, we'll be bringing back to you a regulatory change to implement those that changed in the file specifications at some point.
Okay.
Probably in the foreseeable future, but we don't have anything specific at this point. But I was at least wanted to alert you to that.
All righty. Thank you. So why don't you go jump on ahead right into federal and state legislation?
Joycelyn will join us, our newly appointed Director of Governmental Relations.
Congratulations, Joycelyn.
Good afternoon. As I think you heard earlier, session ended at the end of August, and the governor has till the end of September to act on any bills that reached his desk. So I'm here to give you an update on the bills that the board either sponsored or took a position on this year. And I'm going to start with AB 736, which is regarding the Chief Operating Officer and Chief Financial Officer. So we made some amendments that were requested by the governor's office, and that bill has reached his desk, but he has yet to act on it. AB 1052 regarding the investment procurement process. We received feedback from the administration on that bill and then made the determination that we actually wanted to move it to the Assembly inactive file to do more work internally on our procurement process under our current authority. The next two bills I'm going to address are bills that you took a neutral position on. So AB 1875 regarding electing special needs trusts as option beneficiaries, and AB 2155 regarding the full-time equivalent for adult education and community colleges. Both of those bills are also with the governor. AB 2833 regarding private equity fee disclosure, that bill was actually just signed yesterday. In addition to that, one of our technical housekeeping measures was signed yesterday and the other one was signed earlier. And so both of those bills, SB 1352 and SB 1353, have made it into law. Will be effective on January 1st. Any questions on state legislation?
I don't have anybody in line.
Great. Moving on to federal legislation, HR 711, which proposed a new formula for the WEP, the windfall elimination provision. It was slated for markup in July, so I want to bring that to your attention because that's since the last time I've been able to speak with you. That day, though, they decided not to move forward with the markup, given the fact that not all of the stakeholders were on the same page. So that is a lot of action that we've seen on those WEP and GPO bills more than in the recent past, and so I want to bring it to your attention, but we don't anticipate anything else will happen on those bills this year. So we'll keep an eye out, definitely, of course, in the coming session. Two other bills came to our attention. One was introduced in June and one was introduced in September, and they were actually moving pretty quickly. And they're bills that we are concerned about. And so they're not on your legislative summary. They're not on the matrix that is out there in the back of the room. HR 5424 is the one that was introduced in June and has actually made it out of the House into the Senate, although we don't anticipate it will move further than that at this point. But that bill removes certain registration and reporting requirements for private equity advisors. And actually, Jack was able to send 2 letters of concern on that bill to note that we didn't want Congress to go in that direction. And so those have been logged in the files there. And we will definitely be keeping an eye on that because it seems like this is indicating a trend of bills that are coming up, because then at the beginning of September, it's September 9th, HR 5983 was introduced, and then it actually made it through markup on Tuesday, so September 13th. Wow. So yeah, so it made it out of the House Financial Services Committee, and that bill has a wide-ranging array of issues that it's tackling, but it's really rolling back many pieces of Dodd-Frank, and part of it is dismantling the Consumer Financial Protection Bureau, their provisions repealing or rolling back say-on-pay votes, proxy access, clawback notifications, hedging, things like that. So it's definitely something we're concerned about. Again, Jack was able to submit a letter of concern on that bill, and we will. And that one looks like they're setting the platform for next year for further action in Congress. So we'll definitely be seeing what happens with that and making sure to bring you bills as we can in the timeline so that you can see them early on if we are able to get those to you based on your meetings.
So Joycelyn, I know I had copies of those letters. Did every board member receive those?
They should have.
Already.
And there are copies in the back as well.
Already.
Yes.
I'm just really stunned that something that could be so voluminous was not only introduced, but then in markup within days. That just...
Very fast.
So how do we know if our comments were actually included in the public record?
We actually received an email from, I believe is Congresswoman Waters' office that had us listed with the opposition letters that were submitted.
Alrighty.
So it did get recorded.
Alrighty, thank you, I appreciate that.
The bill is such an omnibus bill. I mean, you'd be surprised who wrote comments from the Restaurant Association to, there's a retail angle to this that's very strong. So there's a lot of parties that are going to be concerned about this bill. Yeah.
Wow. Alrighty. Any questions? Sharon, are you good?
Well, I guess I will ask,
Go ahead.
back to the Social Security, is it HR 973, the Social Security? I can't remember which number.
HR 973 is the repeal of the WEP and the GPO, and then HR 711 is the new formula for
That's 711, that's the new, can you talk a little bit, when you said you don't think there'll be any action this year, does that mean next year that there'll be, I guess I'd like, because I have people ask me about this all the time, and I just wondered if you could share a little bit more of maybe what the conversation was, what were the sticking points, and then...
Right. They did have an informational hearing in March, and so they spoke about both bills. It really focused on HR 711, and then they were looking, I think, they were going to try to be moving HR 711, so that's why they had scheduled a markup. But I think they were also looking for a lot of agreement from all the stakeholders, and since they didn't have it, decided not to move forward with it. But I think this is the most momentum those bills have received in a long time, so and they are, I mean, the repeal is often there. So I think the new,
Don't we see the repeal every,
Yeah.
I mean, every year, so it's-
Exactly.
it's in there, but.
so and I think the approach with the new formula has been the most creative bill that's been out there in regards to these. So I imagine they would try it again next year, and that maybe all of the stakeholders would have had their input received and be in support at that point.
If I remember correctly, and Josie can correct me, I think part of the issue was the issue that the board had with the bills, the fact that it would have affected people who under current law wouldn't have been affected by the offset because they don't get a benefit from us. And I think that was of concern to some of the stakeholders, which is why they couldn't reach that agreement about it and deal with that.
But that is also the provision that allowed for it to be cost neutral or more cost neutral, so then it kind of sets off other issues.
Got it, okay,
Yeah.
thank you.
Okay. The last thing I wanted to mention is that staff are currently analyzing potential proposals for sponsored legislation. So I'll be back in November to go over the ones that we want to move forward and get your thoughts on at that point in time.
Alrighty, thank you very much.
Thank you.
All right, moving right ahead. Ooh, Ed, you're not back in front of us again today?
Is that it?
Dang. Maybe we'll have to do something about
Just
that.
slacking off the rest of the day, apparently.
Don't go too far. Alrighty, Jack, your CEO part?
I was going to highlight just a couple things. First, I wanted to show you just about a minute and a half video that we have out on our social media site. I was on the East Coast some months ago, and a person came up to me and they said that his mom was one of our retirees, and he said, you know, she's 104 years old. She must be the oldest retiree you've got. And I actually didn't know, how old is our oldest retiree? Here's what's on the social media site now. Yay, females.
Wow. Sorry, guys.
Bummer.
Wow.
Love those infographics.
Exactly.
That's fabulous.
So, yeah, hey, thanks, Sharon, for saying that. I mean, I put in our report to you just all the awards that our communication team has gotten this year and the focus they're spending now on social media. But this is just
Thank
another
you,
quick
Joanne.
example, how to communicate, not in just a chart, but something that will get people to have some emotional connection to what we do here. So I thought you'd enjoy that.
So Jack, I have to say, one of the best jobs I think a chair of this board has is signing the birthday letters. So for everybody's information, I signed 25 today.
Centenarian?
25 of our members turned 100 in September. And that's
Yes.
about an average number. It's really amazing.
You're scaring the
And
actuaries.
you get
but
letters back.
Yeah.
But what's really cool is we actually get letters back from their family saying, thank you very much for acknowledging Mom, Dad. Okay, more moms evidently.
Absolutely.
All right, go ahead, Jack.
Absolutely. Just on the people side, I want to let Ashish just recognize the people that have worked really for months now on this boardroom and the boardrooms next door, and then they move on to the tower. And really updating our technology in the building. It comes out so simple looking, but Ashish, you were going to just mention this.
Yeah,
Yeah, please.
so I think everybody is appreciating 4K high definition.
Well, there's ups and downs to that idea. But
Yeah.
yeah. That's a tricky word,
It's
appreciate.
a tricky word, but I think just like Ed mentioned, and we mention all the time about the team, why we are successful in CalSTRS. Our team is tremendous. You know, it's the core is there. Whenever we ask them to do something, they step up. We were a little nervous about it for today's meeting and yesterday's meeting because of the time crunch, but they pulled this off. So here you are. We have a technology services team led by Ben Deng. Yeah, so we have all Alvin, and he's coordinating this one. You always see Jonathan and Alex hurrying around all the time, mouse issue here and there. But we have an excellent communication team. The Krista team did a very good job and working together day in, day out for last 6 months. And Tom, where is Tom? Susan is here. And if we can see the control room, if you can see, where is the control room? Control room, okay. So this is,
Oh, Artie, no one gets to see the control room. Oh my
yeah.
gosh.
So this is just, yeah, every board meeting, we just see only 2 or 3 folks here, but behind the scene, we have the troop is here. So the other, we have the Mark is our blueprint and the engineer who put all together where this is going on, the wireless as well as the seating and the new idea of this. So Mark and where is the other guy? Yay. Yeah, Mike is here. And then we have excellent, the integrator, ABI SPL, the whole team. They are 10 plus team member. They were like working for last 3-4 months. We already finishing this one and we started a next phase. We are refreshing our board, the training rooms and other conference room. Good. Thank you guys.
Thank you very much.
And the shot at the control room was very cool.
I know.
That was very
It's a
cool. Thanks,
secret,
guys.
Place, but they are a very patient group. They put up with me with a lot of ideas on this, so they did a great job.
I'm sure you had some input, Jack. I'm sure you did.
Put up with
And
us
finally,
too.
just two of our most, again, senior appointments that I referenced in the materials, again, in terms of driving our business and the success of what we do. I want to acknowledge Joycelyn, that you've all met and just was up here a minute ago, where you're over there now. And it's wonderful to have a person in this director position that can run on the first day. Her experience, Stanford grad, spending time in the Capitol for a number of years, and then you'll get to appreciate this is such a complicated plan design that we have here, and to discuss bills that are so technical at the Capitol, they are so reliant on trusting that we have people here that are giving them the straight scoop and that understand the plan design. And Joycelyn excels at that, so she's going to really do well with this piece, real well. We're real excited about having her there. And Jeff, where are you in the audience? Right next to us. Over there? Oh, nice, Jeff. Jeff Zimmer, you've seen him a little bit over the years. And again, with a whole different part of the organization, but now as the technology project pension solution is starting to get momentum on execution, now we have to get serious about changing CalSTRS. And so Jeff is going to be very pivotal in that other piece of the project, essentially getting us to think differently about the organization, how we operate and deliver customer service. So this is brand new for us to really have a person positioned as innovation in plan design and innovation in benefit services, helping Andrew think through how we can be at CalSTRS whatever we're on now, 4.0, whatever it is, when we emerge from pension solutions. So Jeff, again, it's hard to find people that love business process, but you gotta love it in order to make the changes that we have to do. You can't just operate at a high level of generality and move an organizational chart around, and then you make somehow the culture think they're gonna perform like that. Well, they don't. It always implodes. We need someone that can lead this effort, that really gets the guts of the organization and can move us and transform that way. So Jeff is perfect for that role.
No pressure.
Thank you, Jeff.
No pressure.
I know. And I think that's all I had to highlight for you today. Thank you.
All right. Any questions of Jack's report? All right, we're going to turn this over to Brian then. Brian, if you can come on up.
I know, it's like a miracle. So great.
So good afternoon. If it please the board, I'd just like to take a moment, personal privilege, to speak for myself and the rest of the lawyers in legal service to express our appreciation and admiration for Ed. I've worked with him many years. He's always been a good resource. We tease each other, but that's what New Yorkers do. Ed's been invaluable. Every time I've had a detailed question about the plan, about politics, about stakeholder relations, Ed has been there. He's been pleasant, friendly, helpful. All of our lawyers rely on him and for his encyclopedic knowledge of the plan. And I know that everyone loves working with him. And from the lawyer standpoint, I just want to say that it's a real privilege to have worked with him, and I'm going to miss him. Okay, I'm going to stop being nice now because I want to talk about a case. And I think after I talk about it for a few minutes, you'll know how I feel about it. I originally was planning to do this to update you on some of the cases coming out of Illinois, but I can just pretty much sum them up and find that the Illinois court has upheld the vested rights theory and overturned attempted changes to employee vested pension rights. Along came a case called Marin Association of Public Employees versus Marin County Employees Retirement Association, decided just a couple of weeks ago. And that's what I want to talk about today. Essentially, this is a case of members versus a system. So there are current members who the system made changes, and they brought suit to challenge those changes. One of which was under a constitutional theory that their constitutional vested rights had been impaired. Yes, they're current members. Yes, they're current active members. The decisions, and the case involves PEPRA and involves a change by the Retirement Association, the board, to on the compensation earnable. That's similar to your creditable compensation, and really deals with three kinds of pay: standby, on-call pay, and then in-kind, cash in lieu of health insurance, those type of things. And it's prospective in nature. So the change is prospective in nature. So the employees, members of the system, brought a writ in Superior Court attacking, again, on the theory of impaired vested rights, the actions of the system. The system filed something that's called a demur. As a legal professor of mine used to say, that's a legal so what. And demur is basically saying, yeah, if we took everything that you say as true, still don't have a case. So the court looked at the plaintiff and the arguments in the complaint and briefing and said, yeah, there's no case here, and demur dismissed the case without leave to amend, meaning they couldn't go back for another shot. Plaintiffs appealed up to the First District Court of Appeal, and they came out with this decision. The holding in the case, the actual holding in the case, basically the court, the Marin court, the appellate court held that prospective treatment of these items as excluded from compensation earnable is that is non-pensionable, did not violate the plaintiff's vested rights. It's limited to active members. So that's the result. It's a result coming out of a legal dispute. But in reaching this conclusion, the appellate court reviewed 61 years of California jurisprudence through what I would describe as a funhouse mirror. The decision is an abomination. It is a result-oriented opinion. It's not difficult to fathom that when the first 4 pages of the opinion recite all of the language that we've heard over the years from opponents of defined benefit plans. The Rouse study, the Stanford study that I believe the CEO gave an F at one point. 4 pages of reciting those those particular studies. So I would tell you right off the bat, you can tell by looking at it, it's a result-oriented decision. So what do? Well, they go through incredible lengths. The court goes through incredible lengths to twist the perspective of the vested rights analysis as pronounced by the California Supreme Court. So and really it is the two-pronged test that talks about some of the fundamental cases. It starts in a case called Allen 1, because there's later another one, in 1955, where the California Supreme Court says you can make a reasonable change of employees' pension rights, but it has to bear some material relation to a theory of a pension system. In other words, you can't just take the money to fund something else. And changes in a pension plan which result in disadvantage to employees should be accompanied by comparable new advantage. You all know that, you're familiar with that. That was an essential component of the funding strategy of the funding legislation. The Allen Court in 1955 used the word should. This is the word that the Court of Appeal hangs its entire decision on, this word. So looking at the Allen decision, again, it says changes in a pension plan which result in disadvantage to employees should be accompanied by a comparable new advantage. But they go through all kinds of efforts to say and to add up all the uses of the word should and ignore the actual holdings of the case. For example, in Allen 1, the court, the same Supreme Court that used the word should, went on to say, in the present case, it appears that Section 187.2, which was at issue, substantially decreases plaintiffs' pension rights without offering any commensurate advantage, and there is no evidence or claim that the changes enacted bear any material change to the integrity or successful operation of the pension system. The court held that that was an impermissible change. So in the actual decision, the court uses it as a mandatory factor, the second prong. So we're talking about, these cases all talk about the second prong, which is the comparable new advantage. Over the next 60 years, the California Supreme Court continued to reiterate the comparable new advantage test in 8 different cases. And as I beg your indulgence, I'd like to kind of walk through this to show you why this opinion is such an aberration. So after the Allen 1 decision, we had a decision in a case called Abbott versus City of Los Angeles, again, which parrots the information, the language of should. So it has the same, it basically quotes Allen 1 and says, should be accompanied by a comparable new advantage. But the Abbott court notes it's the advantage or disadvantage to the particular employees who own contractual pension rights already earned are involved, which are the criteria by which modifications to pension plans must be measured. The appellate court in Marin ignores that language and just says Abbott cites the Allen 1 language and uses the word should. Next along comes a case called Betts, which I know you're all familiar with from prior vested rights discussions. That's in 1978. Again, Betts quotes Allen 1 with the same two-pronged test. But the key language that, again, the appellate court ignores is, and if I'll beg your indulgence, I'll read this. We therefore conclude that the 1974 amendment to Section 9359, which is the issue, cannot constitutionally be applied to petitioner because the amendment withdraws benefits to which he earned a vested contractual right while employed, and no comparable new advantages to petitioner appear in the plan. So again, the Betts court, even though it cited the language in Allen that used the word should, it finds specifically that there's no comparable new advantage and therefore it's an unconstitutional vested right. Moving along in 1980, Olson v. Corey, it's the same. Olson v. Corey, these are all California Supreme Court cases. They cite their own decision in Allen 1. And And without going into that, I do want to again highlight that this is about judges' pensions. And it says such modification of pension benefits works to the disadvantage of judicial pensioners by reducing potential pension increases and provides no comparable new benefit. Again, we conclude that defendants have failed to demonstrate justification for impairing these rights. Again, the California Supreme Court relies on the second prong of the test to find that there was no comparable new advantage. 1983, along comes case Allen versus Board of Administration, which we refer to as Allen 2. Allen 2 is where the word must appears. So there's it's a reference to Allen 1, but the line it says, and when resulting in disadvantage to employees must be accompanied by a comparable new advantage. So this is, again, the California Supreme Court. And the court cites its own decisions in Allen 1 and Abbott. So now it's the California Supreme Court in 1983 saying it's must. As I'll mention in more detail in a minute, the appellate court in Marin treats this as an aberration. Finally, in 1991, the Supreme Court goes back to Allen 1, quotes the language from Allen 1, the should language. And this case is the Legislature VU, where the court states petitioners acknowledge that the state as employer is permitted to make reasonable modifications to the pension system. That's, remember, the first prong. During the employment relationship, so long as employees receive comparable new advantage in return for any substantial reduction in benefits. So now the Supreme Court uses the phrase so long as. A year later, the California Supreme Court in a Huntington Beach case cites Allen 1, but it's not really decided on that basis. As a matter of fact, it says we don't need to go into this argument because there's no vested right here. So the court in Marin, it ignores the actual and complete analysis of each of these cases. So each of these cases talks about whether or not there is a constitutional infringement, unconstitutional infringement of vested rights, applies the two-prong test, and finds that there's no comparable new advantage. Instead, this court, to reach its result in the Marin, diverts from actual precedent and brings what I would call a myopic focus, tallying up the shoulds and ignores the one must, to find, and this is a quote from the appellate court in Marin, we do not believe the word must was intended to be given the literal and inflexible meaning attributed to it by plaintiff. I said that again, I'm sorry. We do not believe the word must was intended to be given the literal and inflexible meaning attributed to it by plaintiff. I think you probably get the idea of why I'm so upset about this case. So the court then goes on and spends a lot of time on the first prong, which is the ability of a government to make changes reasonably related, and talks about the exercise of the police power. I'm not talking about the second prong, the first prong. But it relies in part on a United States Supreme Court case, which is United States Trust case. That case has been characterized by a later U.S. Supreme Court case as saying the Supreme Court has directed that in determining whether there has been a substantial impairment, a court should determine whether the abridged right was replaced by an arguably comparable provision. So the United States Supreme Court authority upon which the Marin Appellate Court relies on says comparable advantage. You have to have a comparable advantage. And then in what I would describe as a face-palm inducing aside, this appellate court then says, in any event, we think there is a new benefit. What the new benefit is each of these employees' paychecks is no longer being reduced by deductions to cover those sums in finding in funding the employee's retirement. So the court is saying that there is, then the court goes on, and in fact says there is a comparable new advantage, and the comparable new advantage is you don't have to make the contributions. And so I want to read another quote. It starts, put simply, and I think with this court that is the apt word. Put simply, the new benefit is an increase in the employee's net monthly compensation. Put even more simply, again apropos for this court, it is more cash in hand every month. So I think you can see why this is extremely troubling. So what does this mean? Well, if the case is published, so right now it's precedential. It's precedential for courts below. It is, as you may have read, it's being used to support DB opponents' arguments, which they're heralding this as sort of a breaking of the California rule, even though these same opponents have, filed various or attempted to file various measures that implicitly recognize the constitutional nature of the protection, because they all contain constitutional amendments. On the other side, people who have vested rights are very concerned, because this language, especially the last quotes that I just read you, the comparable new advantages, you don't have to pay for the benefit. That basically undermines the entire theory of pensions. It's causing a lot of confusion. People like me and other lawyers who are even more steeped in the vested rights jurisprudence are shocked, don't know what to do with it. It comes out of left field. So what's next? Well, the plaintiffs, the unsuccessful plaintiffs, have an opportunity to request review with the California Supreme Court, basically an appeal to the California Supreme Court. The deadline for that is September 26th. There also is and that's limited to parties. There also is an opportunity to request depublication of the decision, and that deadline is October 16th. Depublication of a decision means that nobody else can rely on it. As a matter of fact, it's a violation of a rule of court to actually rely on a depublished decision. But it means that the holding, the case, it still applies to the parties. So the case is resolved as to the parties, but the case is, the opinion is depublished, and no one else can rely on it. I don't know for sure, but I'd be willing to suspect that the plaintiffs are going to seek review, and they are entitled to do that. Anyone in the state of California can seek to have the opinion depublished. So it is possible for anyone who's opposed to the opinion to file a request for a California Supreme Court to say, please depublish this opinion. Adding to this sort of fact pattern, there are 3 cases that have been consolidated. I think there are 3, Contra Costa, Alameda, and I'm not sure what the other one is. I think it might be Madera. Merced. Thank you, Harvey. Have been consolidated in the same court of appeal, but in front of a different panel dealing with the same issues. That decision has not been rendered yet. So there are a lot of procedural permutations that might happen here. The California Supreme Court might just want to hold on to the first one and until the second one is decided. But in the meantime, the troubling part is the Marin decision is a published decision, and so it remains to be seen what will happen with it.
Brian, the demurrer was filed. The lower court accepted the demurrer and refused to hear the case.
Basically,
but that's before there's testimony and all that kind of stuff, right?
The demurrer is based upon the actual pleading. You don't get to add more information. They just look at it and say,
Right.
if you take all these allegations
as absolutely true, everything that the plaintiff has written, you still haven't stated a case.
Right. So when it goes to the appellate court then, is there an actual hearing? I mean, they base their decision on the actions of the lower court.
But they
So
get
like-
to, they get to review it, what's called de novo. In other words, they get to take in evidence and briefing and then make a decision, not based upon the record below,
Okay,
but
not
based
based on
upon
the
a,
record below,
based
okay.
upon a record that they develop.
Okay, thank you. That's where I was trying to go. All right, thanks.
And it's my understanding with relation to that neither party placed this particular argument in front of the appellate court, that this was an argument that the appellate court came up with on its own, that this was not argued by either side. This trying to eliminate the second prong of the test.
Wow. Any questions by any members of the board? Any comments? Harvey, you're our fiduciary. Oh, you had your hand up. You're our fiduciary counsel.
Yeah, I'm sure Harvey will disclose his involvement in this case.
Thank you. No, I was not involved in the Marin case, but I am counsel of record to Contra Costa in Alameda County and the companion cases that are soon to be scheduled for oral argument. I want to echo Brian's alarm on behalf of the members of the system. This ruling, in my view, poses an existential threat to the defined benefit plan. Because quite simply, this case takes the word defined out of the phrase defined benefit. This ruling says that a teacher, Ms. Dillon, can work 29 years paying in towards a benefit of 2% at 60. And in the final year, in the 29th year, the legislature could decide that 1 at 60 is a reasonable retirement allowance and come to you and say, you're going to get 1 at 60. That's what this court authorizes. It goes beyond the on-call and the standby elements of pay that were at issue and literally talks about the formula and says the legislature can change the formula as long as the change is considered by someone, the legislature, to leave you with a reasonable benefit. That means COLAs are at stake. That means the formula is at stake. That means the entire defined part of a defined benefit would no longer be valid. So this is a threat to the entire membership's benefit structure if this case were to become final or if the Supreme Court were to uphold it. And I think it's something that we should watch very carefully and possibly take some action on behalf of the membership. There is precedent for the STRS board in situations like this to actively.
I have to interrupt at this point. I've discussed this with Mr. Lederman, and I don't agree with all of his comments, and I think that that's important. Also, I don't see this as a fiduciary issue, and I think that's important as well. I think the board needs to remember that this is a dispute between members of a system, union members, versus a system such as yours. So there's an actual dispute between both parties, if you will, the members versus their system on attempts by the system to limit perception of spiking. So there is some, if you look at the actual holding of the case, in other words, the actual effect of the case, there are winners and losers here, and there is no real, I think, advisable role for this board in supporting either side. The only role that perhaps might be a correct one for this board, in my recommendation, would perhaps be to seek depublication of the case, because it's so confusing and it's so overturns or potentially overturns, as Mr. Liederman has mentioned, it has, will have such confusing and deleterious effects. But that would be a neutral position. In other words, it would be agnostic as to the outcome of the case, but it would be the reasoning for requesting depublication would be because it is such a bad decision. It's so badly reasoned.
All right, Harvey, did you want to finish up any?
Yeah, and I think although I'm hesitant to suggest closed session on something like this, it might be wise for us to have a closed session discussion about legal strategies and impacts on the system, so that we can consider all these things. The Marin board was, in its mind, carrying out the AB 197, which passed with PEPRA. So they were carrying out what they believed to be a proper interpretation of the legislature's reduction in what was counted as pensionable compensation. But in terms of whether and if the board has any role to play now or in the future on this subject matter,
talk
that's
about that
something
in
I
closed
think we
session.
ought to talk about is in closed session.
Alrighty. I do have a couple people in line to speak. We do have a closed session scheduled for today. Brian, we can't, because this has been mentioned in open session now, even though it's not agendized as a closed session item, we can move a discussion if we want to talk about it today in closed session, correct?
If you want to make a motion to amend the agenda because of the emergent nature of the issue, you could do that. So you could amend your closed session agenda to include a discussion of the
And we would do that in
appellate
open
court
session.
decision. You would amend your agenda in open session, recognizing that you're meeting the emergent standard requiring you to
Right.
discuss this item now.
All right. Then I'm going to turn it over to our speakers and we'll see where we go from there. Sharon?
So, and you can both answer, Harvey, you can stick around if you want, but, so I just want to break it down so I make sure I understand. With the Marin County case, in reading this and previous, kind of going back to some of the cases you were looking at, Brian, the Marin case, there was the perception or assessment that some of the some of the things were accredited to it, a pension was like pension spiking, right? That they were spiking their pensions, that those Marin County employees.
That was
right?
the perception.
Right,
yes.
okay, got it. And then, so I just want to make sure I understood that correctly. And then the language that I saw that the Justice Richmond used, getting back to this reasonable pension, talking about when a public employee does have a vested right to a pension, that right is only to a reasonable pension, not an immutable entitlement to the most optimal formula of calculating the pension. So in your understanding of this idea of a reasonable pension, you alluded to it sort of, Brian, like, so the legislature could go in and make a change, but like who constitutes what a reasonable pension is?
Well, that's actually a subject of litigation, and that's why they look at it through the lens of what the change is going to be, and is the change substantial? And if the change is substantial, then you start going through the test. Okay, is it reasonably related? Is it a proper exercise of the police power? And then if it is, how does it affect those being affected? And that's when you get to the comparable new advantage. And we have additional jurisprudence on that. We have appellate court cases that go into it in more detail. I know we dealt with the issue of the contribution rate, and there's the Pasadena Police Officers Association case that says that the contribution rate itself is a vested benefit. So there are cases. There's at least one case that which is actually in your TRL is CTA versus it's Corey Valdez case that says you the legislature can always find another use for money. And that's the case that says that you have a vested right to a funded pension. So that, of course, is we brought up and discussed in our response to the SCR 105 and in support of the ultimate funding legislation. So there are other permutations. So the courts that have interpreted the Supreme Court jurisprudence and Supreme Court decisions have not concentrated on that first part at all. They've actually looked and really concentrated on the second prong. It's almost as though each case, it's almost assumed by the time you get to this court that it's related to a pension system. But the change is it a vested right? And if you're taking away a vested right, is it there a comparable new advantage? So
I guess I'm thinking of places like Illinois or New Jersey or places where you see, benefits, pension formulas changing based on who gets elected the next time or things like that. And I just think for like our members in California, we've always told them, the California Constitution protects your pension. And I think the idea that somehow some entity out there, whether that's the legislature or who it is, defines what a reasonable pension is, I just think that seems challenging.
and that goes to
Like for
Harvey's
me to plan
point.
my future on somebody defining what reasonable is and having that change over the years seems challenging.
There are states that look at pensions as contractual obligations. You work, you get current compensation and deferred compensation, and it's all in exchange for your work. California is that kind of state. Other states look at pensions as gratuities, as gifts essentially in your old age from the benevolent government. This court even talks about, strangely, the inalienable rights of government. It's a very strange, we usually hear the inalienable rights of individuals. And so somehow this court believes that all power resides with the government to giveth and taketh as it wishes, as long as it's reasonable for someone. So you're right about other states, but even in other states like Illinois, as Brian mentioned, Illinois Supreme Court upheld the contractual basis and struck down the governor's plan to impair those benefits. So now maybe we'll call it the Illinois rule.
And I know that some states actually have it guaranteed in their constitution, so.
Right.
Illinois is one of those states.
All right, Grant?
So, quick point of clarification. So the Marin case is about prospective changes to pensionable compensation. But an example Mr. Lederman threw out there was a retroactive change, where, if I heard you right, you were suggesting that this decision could justify a change to somebody's pension formula after the fact, after they've worked a full career. I've never heard that read of the Marin decision, and it seems, since that case was specifically about prospective changes, I mean, is that a leap?
I'll let Mr. Lederman respond to that. I certainly, I think the court went out of its way to actually, in language in the decision, to say limit its holding to prospective changes for existing members. So that's really, if you were to ask me, that's really from a factual basis what's different here. If you look at coming out of the Little Hoover Commission and other discussions, it was where you have this pension debt and we have these benefits that are promised to current members, current employees, who are continuing to accrue pension benefits at this promised rate. And what some folks wanted to do was say, okay, we're going to consider all those pension benefits up to the extent that they've been earned. And the way we're going to approach that is you only earn it as you go. And so therefore we can make prospective changes at any time going forward. And so, which undermines the traditional version of vested rights, which is you sign on and you agree to work over a period of time, and you accept the promise of the governmental entity, and you continue to work under those conditions. Interestingly, in a incredible footnote, this court compares the current view of vested rights, that view that you sign on and you continue to work, compares it to an NFL signing bonus. So if you want to see the bias of this court, looking at that footnote where it says basically there's no NFL signing bonus in state government, and you can just change it up until it's earned. If it's earned, then, but you don't have that promise of that level of pension going forward. And now, if we take it away, we don't have to give you anything in return other than the fact your contribution, you get to keep your contributions, you have more cash in your pocket. So that's the real troubling aspect of this, is turning this whole area of jurisprudence right on its head.
But it's still, the way you read that decision, they still recognize that anything earned is not
Yes,
changeable.
they
Yeah.
specifically
Okay.
mention that, yeah.
Yeah. That's my question.
Harry?
Just a
Comment and observation. Thanks for bringing this to our attention. I don't think there's anything more than I need today. We rely on our counsel, and our counsel clearly has stated his strong disagreement with the court's decision in this matter, and has expressed why he believes the court erred. And that's good enough for me at this stage of this process. The larger, I think, message and issue for me, and I think for all of us, is just to continue to be mindful and on our toes that there are some threats that are real and maybe some that are imagined that could potentially disrupt and be a threat to the benefit that our teachers have, our educators have earned and have a legal right to. And that our oversight responsibility is that when appropriate, if there's a real threat there, that we will take the appropriate action. At this point, I just see this as informational, and that there's a disagreement, fierce disagreement, between what our counsel views how the court ruled in this. So for me, it's, don't rest on our laurels because courts or political decisions could potentially undermine the benefit that we have taken an oath to uphold and protect. And so I appreciate you bringing it to our attention. I think if there's any strategy decision, et cetera, those would be privileged to close session. So I just want to make that comment.
Tom?
I had one question about the decertification, and if this should be closed session idea, then tell me and we'll do it then. But on what basis can we, and who do we petition? Do we petition the appellate court that made this decision, or do you petition the Supreme Court?
You file a request directly with the Supreme Court. Anyone could do it. And the basis would be pretty much the basis I just outlined. I mean, a little bit more restrained and perhaps more scholarly, but it would be that basis. I mean, the confusion, the limiting of precedent by the higher court. I mean, the request for review would pretty much write itself.
So I have, Paul?
Just following up on Tom's point, so depublishing would be a decision by the Supreme Court, and it's already been announced that there will be, that the plaintiffs are going to take this to the Supreme Court for review, right?
That part, as I said in the beginning, I don't know that for a fact.
Okay.
There's been no.
There've been press
been no
reports to that effect. Okay.
But no official announcement that I'm aware of.
Okay.
The court doesn't have to accept it.
Right. No, I know the court doesn't have to accept it. So I guess the question would be: is the court in the practice of of, depublishing an opinion, an appellate court opinion, but not accepting the appeal to the Supreme Court?
Well,
Does that
it
happen?
is-
I mean,
is
it would seem to me that they would be, I don't know, that's,
There are alternative approaches. The easier route, of course, would be to depublish and wait for the better case to come up. But I will tell you, talking to folks who observe the California Supreme Court more than I do, depublishing is rare. It is rare. So requests for review, it's rare. They get, don't know what the statistics are, maybe Harvey does, but they get plenty of requests for review, and they choose not to take cases.
I'll give you an example. Last year, the same appellate court, different panel, in a case called Protect Our Benefits, it was a San Francisco ordinance about COLA, cited the same cases, the whole line of cases, and came to the exact opposite conclusion on vested rights. And that was a petition for review, went to the Supreme Court, and the Supreme Court turned it down and did not review it. That was last year. Same appellate decision, 180 degrees, the same appellate court, 180 degrees different view of vested rights. The Supreme Court didn't accept the petition. It's hard to know. Up until last month, the Supreme Court's rule was that if it accepts review, it automatically causes the lower case to be depublished. They changed that this month. And they said from now on, that's not going to be automatic. If it's going to depublish, we're going to do an affirmative action to depublish if we don't want it to stand. So it's hard to know where this is all being reinvented in the last 30 days at the Supreme Court, so we don't know which way it'll go.
So my question, it was a three-person panel on the appellate? Can they ask for, isn't there something like en banc, that you get more, you get the full,
Not in the state courts.
not in the state courts, that's only federal? All right. And what is the timeline for the state Supreme Court to be reviewing?
There is no real timeline for the state Supreme Court. There's a
Or a
timeline
cycle.
for filing requests for review, which is September 26th, I believe, at least by my reckoning. And then there's a little bit later, October 16th is to request depublication. So it's a little bit longer.
So if something happens in a timely fashion, the request is made to the Supreme Court, how long does the Supreme Court then have to decide?
I'm
Is
not,
there any type of?
I don't believe that they have any requirement.
All right. So, a couple of people have talked about things that we might talk about in closed session, but for us to talk about this in closed session in a deeper manner along the lines of possible action by the board, we actually have to add it to our agenda. So we need to have a motion to do so. And so if any, and that is the timeliness of the issue before us, and
Yes, the deadlines, should anyone want to take any action, the deadline is September 26th.
that's before our next
on
board meeting.
On the review, and October 14th, because it's a Friday, would be the last day to file the other requests.
All right. So we have a motion to add this to our closed session agenda. Is there any further discussion? All in favor, say aye. All opposed, nay. Any abstentions? All right, we're going to add that into our closed session at the end of the day then. Thank you, Harvey. Thank you, Brian. Is there anything else on this particular? Do you have any, do you have?
That was fun.
That wasn't enough. Do you have anything else for us, Brian,
No, that
on
was, I think
legal stuff?
that was enough for current
Yeah, it's enough
pension
heartburn
cases.
for right now.
Thank you.
Alrighty, Harvey, I guess you don't go very far.